I received an email on Good Friday, a public holiday, 29th of March 2024 at 15:37 p.m, formally notifying me that my Valuation Appeal Board hearing had been scheduled for the 11th of April 2024. It stated your attention is also drawn to the following. 1. Should you fail to appear, the Appeal Board may dispose of your appeal in your absence. 2. You may be assisted by a legal representative or professional valuer at the hearing at your own expense. 3. In terms of the provisions of the Act, the Appeal Board may conduct an inspection of the property concerned. 4. If you wish to supplement or amend your grounds of appeal on the day of the hearing, application in this regard must be to the Appeal Board, who in its sole discretion may condone the late submission for good causes shown. And then bizarrely, this hearing will be conducted in person. Strict COVID-19 protocols will be adhered to during these proceedings. Well, COVID restrictions were lifted 2 years ago. It went on to say, please advise our office if you are in isolation or in quarantine at the date of this hearing, so that we may arrange for a postponement of your appeal hearing. You will be advised should this hearing be cancelled due to the implementation of more stringent COVID-19 alert levels. I mean, this is a government body. How could they be so out of date? Anyway, it goes on. Please note, the appeal hearing will be recorded. The recording of the in-person appeal hearing will be done via a cell phone owned by the Valuation Appeal Board Secretary. I assume that's Fanny Pangolo. The recording of the remote hearing will be done via the recording facility on the Skype for Business application. The recording will serve as a minutes of the hearing, which is required in terms of the Municipal Property Rates regulations. All recordings will be deleted from the cell phone device once it is uploaded to the SharePoint site. Why? Why would you delete something? I don't understand that. The SharePoint is accessible only to individuals who require access thereto for the purposes of the further processing of the information, which is related to, compatible with, the original purpose for which the information is collected. What does that mean? What does it mean? Kindly note that by accepting and or joining the appeal hearing, that you consent to the appeal hearing being recorded in the manner mentioned herein, as well as to the further processing thereof. Then at the bottom of the page, you have to click in to a mail attachment. You click on the mail attachment, it then takes you to your calendar and it puts in the meeting for you. And then if you click on the meeting to the right, this comes up. It gives you the hearing number, which mine was 097. It tells you to go to Media City in Cape Town. It says it's 11th of April 2024, 9:30 till 3. And it then gives you a list of who is attending the hearing. There was no agenda attached, so I had no idea what was going to be discussed. And there's certainly no names of any city quantity surveyor, an engineer, or any of their attorneys. I'm in the High Court reviewing the GV2018 VAB decision. We should never have been here. You know, the valuation should have been suspended until the outcome of the court process. But that's another issue. On the 5th of March 2024, the City of Cape Town attorney Deirdre Oliver wrote to my attorney regarding my case number 4672/2023. She's referring to a letter of the 23rd of February 2024 and my attorney's 28th of February 2024 reply. This makes me laugh. Olivia says, to save costs, the counsel employed in both your client's Valuation Appeal Board as well as your client's damages action against the city are the same. She has a senior counsel, a junior counsel, God knows how many assistants. Why does she need all these people? I've just got me and my attorneys, 2 attorneys. We don't need senior or junior counsel. Why don't they get rid of Olivia and just have senior counsel Ron Pashk? That to me makes sense. Hey, come on people, this is your money. And then she dictates dates on when we have to have everything by, and what, just because I have to dance around the availability of Ron Pashka because he's off earning loads of money as an acting judge. I mean, this is not justice. This is an abuse of power. In any event, we weren't expecting them to attend the 11th of April 2024 hearing. There was no mention of their names. There was no mention of their QS or anybody else. The only person that was going to be representing the city was Angela Jeptha. When we got to the hearing, we had no idea who was going to be there. And surprise, surprise, I don't know who she is, but there's Deirdre Oliver. She's the city attorney. And there he is, Ron Pashka, acting judge, senior counsel. Oh, my word, the city can't move without him, and Olivia can't even speak. Just as we were going to go into the VAB hearing, I saw a gentleman. I didn't know who he was, but I just wanted to put on record with someone that I needed the voice recordings right after the meeting. What I would like from you, sir, is I need the voice recording of the whole meeting.
The voice recording?
Yeah, but I need it today, and I need you to promise me you're going to send it at the end of the day, and I'm not going to have to wait for it. Promise me. And I believe you.
Right, I'll send it to you, yeah.
Thank you, my darling. No, I must have it, because this is serious. Fanny Pongola never sent me the recordings as he promised. Once again, I put my trust in a city official, and they just don't do what they say they're going to do. Instead, another farce. I couldn't get hold of the recordings. 16th of April 2024, after midday, Shaheida-Samodien Azad emailed me with a WeTransfer saying that the link of the recording would be available for 7 days. Okay, these were the VAB members and chair, and if you remember, I had to draw a diagram of all the people that were there because there was no agenda, there was nothing that I didn't know who was there. And I'm just going to play the beginning of one of my recordings. This isn't on the official recording, but I'll play up to where the official recording starts, and you'll hear it sounds a bit strange. I think they've probably edited all of my stuff off. And of course, that then raises questions. What have they edited after the meeting finished with the city attorneys? Anyway, listen, see what you think.
Good morning. Before we start the recording, I just want to establish who's here. There's so many people here.
We didn't get an agenda or anything. We had no idea who was coming. We didn't know who was coming.
No, that's why I want to establish.
So if someone had told us, in in advance, we could have prepared people. So, no, sorry, no, that's not fair.
No.
That's called,
I just
that's called another ambush, sir.
As I said, we're not recording. I just want to establish who's here. So from your parent side, it's yourself. I assume, I just want to say.
Yeah, I actually started writing here, but I'm going to do it again now.
No, I just want, at this moment, we're not recording anything.
I'm recording, sir.
No, I just want to establish who's here.
I know, so do I, but I need it for the recording, sir. Okay. This is a criminal matter, okay?
Criminal matter?
Yes. Okay, so you understand?
No, I'll introduce myself. I just want to establish who's here before I introduce the board. That's the procedure. I just want to establish here when I start addressing everybody, then I know. What's your name?
My name?
Yes.
Chrissie Phillips.
Phillips.
Or Christine, if you want to do it more.
And Mr.
Attorney Barry Barker.
Barry Barker.
Yeah.
And on the other side, who do we have here?
Thank you, Chairperson. My name is Advocate Ron Pashka. I'm
how do you spell that?
P-A-S-C-H-K-E. And I'm instructed by Deirdre Oliver, who is from the city. So we're on behalf of the city, and Deirdre Oliphier's firm of attorneys is Fairbridges, Bertime and Becker.
And she is sitting to your left.
And do you need to know the names of the people who will be giving evidence for the city at this stage, or do you just want to know?
No, that's not it. I don't know.
Okay, thank you.
That's fine. Right. We can start.
Excuse me, sir. If I could just have the names of everybody in the room.
The advocate is the only person.
The advocate isn't controlling this meeting, so you are.
But I'm
Okay, so there's 1, 2, 3. That lady's got Fairbridge, right?
No.
That's Mr. Muppet.
I'm not.
I assume that's the QS. Mr. Stratton? Mr. Stratton? And what's your name again, sir? Oh, excuse. Okay.
I will do those introduction, but the other persons are not relevant at this stage.
They are relevant to me, sir.
Right. You can start the recording from the side here. For the record, good morning to one and all. Today, for the record, is the 11th of April, 2024. Side here. For the record, good morning to one and all. Today, for the record, is the 11th of April, 2024. Welcome to the formal sitting of the VAB2 for the local municipality. Just for the lay people or everybody, the Municipal Property Rights Act number 6 of 2004 was amended, came into operation on the 2nd of July 2005. The regulations came into operation on the 18th of October 2006. Now, please allow me to introduce the board to you. My name is Mr. Mohammed Iso. I was duly appointed as chairperson. I'm a practicing legal practitioner. The members of the board, firstly, it's Mr. Henry Wiggins. He's a professional valuer. Mrs. Karen van der Pfeiffer. She's also a professional valuer. The secretary of the board is Mr. Fani Pongolo. And I just want to stress the members of the board are all independent professionals. We are not employed by the municipality, and none of us has any material interest in any matters that's here before us. I just want to clear that up.
Can I just ask one question? Who actually pays the VAB members' salaries? I just am interested. Is it the DA or?
No, the Western Cape government. We get paid by them.
You get paid by where, sir?
Western Cape government.
The Western Cape government. So
paid
basically,
yeah.
So Anton Bradell is your.
Yeah, whatever.
Yeah. No, that's all I need to know. We thought that.
Yeah.
Okay, thank you.
May I interject?
But what I must say, the municipality, the Western Cape channels the money to the city and the city government. We are employed by them in a sense, although we are independent. Okay,
thank you.
We're not part of the city.
You know that I met you both before. And I have emailed you recently. I did a copy you into it. Yes.
So it's Mr. Esau and Mr.
Wiggins and Mr. Van der
So
Pfeiffer.
before we start, I just want to place on record the following. Okay.
Yeah, but I'm not done yet.
Okay, sir.
I just believe that the members present constitute a quorum. As
Sorry, sir, I can't hear you.
I just want to believe that the members present here constitute a proper quorum to have a board.
Yes.
To have a board.
Can I ask you, are we under oath?
No, we're not there yet. We're not there yet. It's stipulated in terms of Section 68 of the Act, and that all statutory requirements relating to proceedings specifically pertaining to the various declarations have been met. I therefore declare the VAB open to consider the matter and roll for today. The record of proceedings will be, recordings of proceedings will be done by the secretary. And the board
And the secretary is?
Mr. Fani Pongolo.
Oh, sorry.
Right. And as I said, the proceedings are normally more or less in line with court proceedings, but we can follow, in a sense, our proceedings. And if we need to adjourn, if something we need to discuss, we'll do so. Okay? Right.
Do we have an agenda? I mean, what is the structure?
The agenda, because this is the only matter on the roll. Normally, the agenda follows in terms of saying this matter is appearing before us, and who's appearing for the appellant and who's appearing for the city.
Okay.
So
because the last thing I heard that they were trying to postpone it. Is that not happening now?
No, as far as I'm concerned, an application for a postponement is going to be brought to this board this morning.
Yeah. So
that is What I understand is the application is
Okay, I'm just asking why all these people are here if there's a postponement application. Because, and also I'm just asking why I wanted to know what was going on. I wanted an agenda. I wanted to know who was coming today. This is an ambush, sir. You know, this isn't how you run a meeting.
No.
As you know, Ms. Oliver says, this isn't how you do it.
No. What happens here, I can assume, let me tell you, there's an application for a postponement. An application means the board has to decide whether the matter postponed.
I understand.
And if we don't postpone the matter, I assume they want to become prepared and say the hearing continues. They need to have their...
But we haven't got our experts here.
No, but
because we didn't know.
No.
We thought it was just a postponement.
No. As far as I'm concerned, there's an application for postponement and you are opposing the application.
I understand that, sir, but we didn't know. I asked who was going to be at the meeting. I didn't know these people were going to be here. I said if the QS was going to be here, that my attorney could discuss it. It's just that this is so tiring.
No. The point is, as I said, the board will decide whether we postpone the matter. Okay. It's entirely up to the board. And I assume they just want to be ready in case the board says we're not going to postpone this matter. So, Mr. Barker, you...
Yes, thank you, Chair. Okay. So where we are is as follows. Okay. On the 30th of January 2024, under cover of an email from my office to the Valuation Appeals Board, I wrote, "Dear Sir, Madam, please find attached my client, Ms. C. Phillips, duly executed appeal application form plus her covering letter. The annexure to the appeal can be downloaded via the below WeTransfer link. Keep in mind that date, 30 January 2024. The covering letter read as follows, and this is highly important for this meeting, and as far as I see it, this will eliminate this meeting immediately. Okay. 30 January 2024, Dear Valuation Appeal Board, I'm submitting my appeal to the GV2022. This is a letter from the desk of Chrissie Phillips. I wish to place the following on record. The judicial review of GV2018 VAB decision is currently underway in the Western Cape High Court under case number 4672 of 2023. Point 2. As far as I'm concerned, no new rates valuation of my property can ever take place until such time as the court pronounces on the above matter. 3. I therefore request you to suspend any new valuation of my property until 2 above takes place. 4. Should yourselves, however, refuse to suspend the GV 2022 until 2 above takes place, I'll make it perfectly clear here that I will not have any individual who was involved in the GV 2018 VAB hearing involved in the GV 2022 VAB hearing. The individuals I refer to, Martin Coetzee, who's not here, we understand he's unwell, we don't know where he is. Mr. M. Essel, which is yourself, sir. Mr. H. Wiggins. Chris Gavor, I don't know if he's here. C.L. Douglas, I don't know. Mr. R. Wade, I don't know. Ms. L. Muller, I don't know. Municipal Valuer, Llewellyn Lowe, I don't know. Assistant Municipal Valuer, Angelo Jefter, who I see right opposite me. Civil City of Cape Town Engineer, Mr. Moffat, who's right over there. City of Cape Town Attorney Deirdre Oliver, we know she is. Mr. Pashka, we know he is. Shaheida-Samodien Azad, I don't know if she's here. None of the individuals who were observers to the GV 2018 VAB 2020 hearing and the 14 April 2022 hearing. Point 6. Should any of the above individuals be present at the GV 2022 hearing, I and my legal team will immediately leave the venue and will then apply to the Western Cape High Court on an urgent basis for the rescission of any decision the VAB has made in my absence. The only the only individuals I'm requesting to be present at my GV 2022 hearing are as follows. A completely new board, not the case. A completely new City of Cape Town back office staff contingent, don't know. New city legal team, same legal team. And the only person here is City of Cape Town, FWJK Quantity Surveyor, Mr. Ryan Stratton, I'm sure is that gentleman there. We asked for Juliet Leslie and we asked for Sandra Husby. I've now formally put yourselves on notice as to the way I will conduct myself going forward in any VAB hearing of GV 2022. Okay, so we're sitting now with this problem, okay? And my client laid out clearly in terms of this letter her position. Now, both yourselves are witnesses and parties to the judicial review application in the Western Cape High Court. Okay, so this entire So this entire proceeding.
Explain to me. First time I'm here, I'm a witness in a case.
Okay. Yes.
I've written to your attorneys. Have your attorneys not been in touch with you? I've written to Adrian's attorneys.
Which attorney?
You'll find out. They know.
Okay.
They're supposed to be
News to me that
Okay,
I'm a
but
witness.
be that as it may.
No, news to me that I'm a witness.
We are now litigating in the Western Cape High Court, where we're overturning, in the process of reviewing and setting aside the decision of the previous VAB, who was Mr. Martin Coetzee. That VAB decision also involved yourselves and Martin Coetzee at the previous meeting, and you will recall my presence there and my client's presence there. So we cannot now do the same thing, where the same people can be involved today that were involved previously, when that case is subject to litigation in the Western Cape High Court. There's no point in doing it, and this entire meeting has no basis whatsoever. You can shake your head, sir, that doesn't change facts. So what we're here with today is as follows. My client made it very clear what her intention was. Her intention was as follows, that if you're not prepared to suspend, and this is the important word here, suspend indefinitely this matter, this GV2022, then the only way this matter can proceed today is without the two of you and without the relevant persons that I've mentioned. We cannot proceed further today. So if that's the case, and we indicated that if that is the case, that we will leave and this cannot proceed. Okay. So I want to make it clear also, and I'll do it in advance of the application for postponement. And I'll say that right now to kick everything my learned colleague Mr. Pashko and his instructing attorney Mr. Olivier into touch. And I'll give you a little timeline. We need to travel the path as to how we got here. Okay. So already last year.
What are you going to raise now?
I want to explain how we got here.
Good. No, I don't want to hear that. I'm afraid I'm not going to sit here and
Okay.
hear
Can I
history
just
of the
suggest
matter.
something?
That is not what we... Remember, let me just put your... As far as I'm concerned, I'm here to deal with the value of the property as with the GV22. Nothing else.
You can't.
No.
Because it's to do with
That's what for you to say.
Yes, it is.
It's
But
not-
you're in court papers. Your name's on in court
Yeah.
papers. So, and this is the issue.
Yeah,
here.
but I'm not going to entertain you going into the history of this matter. I'm afraid that's not...
Okay, well that's fine. We've got it on record, so let's stop. We're going to leave now, but just before we leave, I just want to put on record, okay? For the last 2020, excuse me, sir, the last 2020 hearing,
Wait a minute.
I applied to hire for the very report they are putting
Mr.
in now.
Barker,
Okay?
what I've seen,
And
sorry.
I applied for the speaker, and the speaker refused me the information because it was subject to a court matter.
Could I just-
I want to know why Deirdre Oliver has submitted all the reports that I asked for the 2020 meeting that we were with you, and they never bothered sending an attorney, they never bothered sending an engineer, they didn't bother sending anything. So as far as I'm concerned, this is totally corrupt, okay? So we are leaving, you carry on with, doing what you're doing. We've made our position clear. We made our position clear before. You sent no agenda. We didn't know who was coming. This is not how you treat a ratepayer, an honest, law-abiding ratepayer, sir. Really.
This is a matter where you...
Look how many people are here. You think that's fair? How do you think someone in Mitchell's Plain or the Burqa can afford to fight this? We should all be ashamed.
You applied to have your valuation appeal matter.
Yes, indeed, on certain conditions.
On certain conditions.
So that's
Now you're moving out of the
But you
hearing.
will be able to testify at the appropriate forum, sir.
You are conflicted,
You are
says
conflicted.
Mr. Wiggins. This cannot proceed. So if you
This
don't
cannot
want to,
proceed. We
you
made
don't want to
that very
stand,
clear.
you don't want to stand down.
No,
You've
we-
made up.
I told Anton Bedell this, and I told Helen Ziller, so, I'll just write to them now when I get back and send them the recording and explain what's happened. This is not fair, sir. And I'm also meeting with Hannah Gleenit as well, who also has very serious issues with the corruption at the city. And exactly what happened in my client application is exactly what's happening to Hannah.
Thank you very much.
It's a symbol. It's a.
Mr. Varkel,
But we're getting there.
Mr. Varkel, before you leave, there seems to be a tendency, you know, in practice, when you have an attorney or legal, the correspondence normally done to you or addressed. It seems to be.
Olivia addresses me directly, sir.
It's not
Thank you very much.
ethical to address via a client directly an attorney.
You're welcome.
I'm not quite understanding
No,
what
no,
you're talking
you know,
about.
when you practice, normally
I know
correspondence
but
address.
what specific instances
No.
are you talking
I'm just saying it seems to be like, yes, she's talking, you're representing her.
She can talk. She can say anything she wants.
Yeah, but that's what I'm saying. There's no sort of, we need some structure.
Sir, I want to just explain this to you.
Yeah.
I'd like you to hear this, Chrissie. This is not a first date. Okay, this isn't the first
No,
road
as far as-
Okay, let me finish. We've been around the block here. This is old school. We've heard it all before. This is the divorces in the process. There's big money involved, and I don't need to reinvent the wheel. We've laid out the conditions. Okay, we said what will happen if certain individuals are here. We told you guys in advance, months ago. So why are we here? If you came back and said, there's a new board, you're not involved, fine, but you didn't. So here we are, and you did it at your risk because you were put on notice. This isn't the first date. We've been around the block. There's a huge divorce proceeding that's going on, which involves your colleague, Mr. Chrissie, and the two of you are involved in that case as well. I don't know how much you know about it, but that's besides the point. You can ask the attorneys for Mr. Chrissie, Adrian's attorneys, and I'm sure they'll gladly give you a copy of all the papers. So this is where we are right now. As to whether my client can speak on her own, she can decide what she wants to do. There's been a modus operandi since day one. Ms. Deirdre Oliver writes to my client directly. So it's not a thing of I know as an attorney how to practice. I know how to practice as an attorney. I've never had an issue with the previous law society or the Legal Practice Council. I really don't need an ethics lecture. Okay. So I've laid out our position very clearly. You people can do whatever you want, but any decision that comes out of here is meaningless, a nullity.
Yeah.
And if there is to be one, we will apply that at rescinded immediately. Thank you very much.
I just want to place on record, as far as myself and Mr. Wiggins are concerned, we're not conflicted. We're not conflicted.
Well, that's your
It's on recording, so if you don't do it,
Bye-bye.
that will be also taken issue with the courts, okay? Thank you. Alita continua.
What did you say? Mr. Wiggins. Gentlemen, I don't know if you wish to say anything.
I expressed my shock at that behavior.
Would it take your question?
Yes, that was gone.
So the meeting's not stopped?
Do you think it's stopped? That was working. Oh, sorry.
So I'm quite frankly shocked at that display. The city our attorneys will take instructions on the possibility of reporting this matter to the Legal Practice Council.
Yeah.
So I think that's the appropriate body to deal with the ethical issues that arise from what's happened.
Yeah.
May I address the question of the further conduct of this matter?
I was looking at just tracking this matter from the road.
Yeah, I think that's appropriate. The city would not want to ask the board to make a decision on the valuation. It would not be appropriate.
Yeah. So I will,
both for the reasons set out in the postponement application
Yeah.
and because the other side is not present.
you know what happens is that the way I look at it, and you can tell me if they brought the application appeal for against the value that the city ascribed to their property. They've now walked out of the meeting. So as far as I'm concerned, they've almost in a way reneged on what they wanted to do. So I'm going to strike this matter from the road. They can bring it back on the road at any time they wish to.
Could I ask instead that our postponement application be granted in the terms that we've sought? Because that application seeks an order, and it's very well motivated, I believe, I submit, that the matter be postponed sine die pending the final determination of the pending review. Then that's a substantive decision made by the board to not hear this matter until the court makes a decision in the 2018 review. There's several good reasons for that. If you wish me to address that, they're set out in the letter in the postponement application, and you would have seen those. But I can address you on that.
I've seen the application and the affidavit of Deirdre. Why does that have an impact on the GV2022?
So the challenges, well, a couple of reasons it has an impact. One is that this board would be bound to make a decision, not in a stare decisis sense, but it would be bound to make a decision consistent with the previous board's decision until that matter is set aside on review.
But we're not bound by any other board's decision. Whatever happened in that board, any board decision, we're not bound by any decision. I'm just raising this. As far as I'm concerned, this is the de novo proceedings.
Yes. So if that is your view, I think that's probably correct. I wasn't suggesting that you have to follow that board decision, but there's an argument that and you couldn't make a decision that's inconsistent. But I accept your view that this is a de novo decision. But then that raises another difficulty that's also raised in the postponement application, is that if this board makes a decision, so the challenge to the 2018 decision is not just that the valuation decision was wrong. It's also about a whole series of procedural attacks on the integrity of the board and bias and the kind of issues which were raised this morning. And the court's going to be asked to deal with those issues. And hopefully the court will uphold the city's position is that the previous board acted correctly, and there's no basis for the attack on that decision. But if that decision hasn't yet been made and this board makes another decision, then what's likely to happen is another review application and then two matters before the High Court, both dealing with the same kinds of issues, not the substantive valuation issue where I accept your view that this board is not bound, but all the other side issues. And then we've got a duplication of litigation, and the city and the parties won't get any further to resolving the dispute about the valuation because of all these other unresolved collateral issues.
I hear what you say made practical sense in the sense that the review, do you anticipate another review should you make a finding?
Yes.
That is my concern. I'm not so concerned with that review.
Yeah.
Obviously it doesn't apply to us or this board when I refer to us. Whatever happened there is no disrespect, we're not going to concern ourselves with that. But it makes sense that you're saying that there may be another review.
Yes.
In terms of what we're going to decide. Because
Yes.
I'm clear of the view this is a GV22 matter, unrelated to whatever happened before, whatever witnesses were there in that matter. It's starting afresh now. I don't know, even the value of the city, I don't know if he probably made a new valuation, I suppose. He's sitting here. So he wasn't bound by whatever happened. The market trend established what the value is into 2022. So it's completely new. It's the horse of the... I don't want to be caught up in this whole quagmire of what happened before. So, but I agree in the sense about the concern that this matter may also be taken under review. And then we have but I'm just stressing, we're not. No, it's not the reason for us going to postpone the matter, but just in anticipation with whatever might happen.
I accept that completely. This board is not bound substantively by the previous board's decision. It can make a new decision, but my concern is avoiding a proliferation of litigation and dispute.
Yes.
And so any substantive decision by this board it's been promised by Ms. Phillips that she'll take on review again, and we want to avoid that.
So for the record, you can also just, we're recording the proceeding as to why you feel a postponement is better than maybe striking from the role? Could you just place
Yes,
it on the
so-
record and the reasons for it?
Sure. So that there's been a formal application for postponement in the term set out in that application, which is, let me just refer to that notice of motion. So the order requested is that the hearing of the GV2022 appeal by Ms. Ms. Phillips in brackets, is postponed sine die, pending the final determination of the review of the Valuation Appeal Board's decision regarding the GV2018 valuation under High Court Case 4672/2023, in brackets the GV2018 review. And then the second prayer is that Ms. Phillips must pay the City of Cape Town's costs of the postponement application and the wasted costs of the day of 11 April 2024. That order would then, your question is what's different between that order and striking the matter from the roll. The city's incurred considerable expense in both making its postponement application.
Can I just interject there?
Yes.
Notwithstanding the cost incurred and so on, between the two, in the scenario that happened here, wouldn't striking from the roll be a better position? So could you just...
So the effect of striking the matter from the roll is that it can be re-enrolled.
Yes.
And then we have a repeat performance of this exercise with further costs, and further wasted resources. A decision to postpone the matter pending the review means that the matter can't be re-enrolled because there's a postponement decision, and all that could be done was to possibly challenge a postponement decision, but that would be a very different. It would be difficult to challenge the exercise of the board's discretion in postponing the matter. So a postponement would mean that the matter can't be re-enrolled. Whereas the striking from the roll means that we'll be back here in a month's time.
The flip side of it, if the matter is postponed, it's almost like the matter is parted. It has to continue. Whereas with striking, it's in, the matter's, it's done, it's concluded.
Well, it's
they've taken the option of not wanting to deal with the matter.
But it's not dismissed. So so the striking of the roll would mean there's no decision on the valuation.
Yes. No.
And then it can be re-enrolled for a further appeal.
But you're aware of Section 55 that the value stands?
Yes, the valuation would stand. Yes.
Until they re-enroll it.
Right, but my concern is to avoid the re-enrollment, because then the city's fully geared up to conduct the proceeding today. Those costs are now wasted, and if it gets re-enrolled, we're going to gear up again. We're going to have further costs, and then another performance and working out, and then it's going to be further costs and no resolution, or it's going to result in a further review. Whereas the postponement until the review has decided and the High Court has dealt with the attacks on the board would mean that there won't be controversy about the 2022 valuation until the High Court's decided the matter.
Okay, the other fact, if we postpone the matter for what? Besides waiting for the review, postponing for what?
So when you say for what, do you mean?
What are we postponing it for?
Do you mean for what date
there must be
or
a
what
purpose.
reason?
Yeah, for what reason? You can't just postpone a matter. We postpone a matter A, B, C, D, or whatever.
Yes, so those reasons are set out in Ms. Olivier's letter. And I submit that they're all valid except that I accept what you say, that the court's not, the board's not bound by the GV, the last decision. But those on Ms. Olivier's letter, paragraph 5, and that letter is Annexure DA03 to the postponement application. So I'm not going to rely on A and B. Do you have that documented?
Sorry? See your prayers, where did I see? I initially had your prayers, A and B. Let me just see A and your prayers. I just want to see where it is. Oh, is this the letter?
Yes, it's the letter which we asked to be read. It's been incorporated. So we've debated A and B, and I accept that on the substance that the board is not bound by the previous decision. But C is that, so reason C would be that the court's reasoning in deciding the 2018 review will inform this board's decision in relation to issues which are common to both matters. So that's dealt with in D. That there can be a consistent decision, and just to amplify on that, there's evidence about the key issue in dispute is whether
you refer to D.
Yes.
I only got those letters up to B.
We're dealing with the annexure to the postponed application.
Sorry, someone got a hard copy there?
Yes, is it part of, yes.
Someone got a hard copy?
Copies that we complete.
Because the copy I'm looking at only goes up to B. Thank you. Take your time. Oh, wait. Oh, you. How come we don't have this?
No, I think you just paged down quickly.
Oh, is it?
There. Yes.
Okay, I'll have the hard copy in front of me. Makes it much easier.
I think so, yes.
Okay, that's fine. Carry on. Have you got it?
So this one is 4th of April.
No, that's okay.
This is the postponement application.
Yeah, no,
It is the letter of the 4th of April.
that's the letter, fine. Edward Pascal, you can proceed.
So, so B refers to the fact that, C says that the reasoning in the GV2018 review will inform the decision of this board deciding the 2022 appeal in respect of issues of considerable controversy that are in dispute. So this is, I'm adding to the letter, that the issues that are mentioned in A, that the main issues in dispute are facts that have been decided in the previous decision, and those are about whether there is structural damage to the building and what the remedial costs are. And the basis of the city's case in this valuation is that the same evidence that was laid at the previous board is still relevant and still applies, and that evidence is in dispute, and that dispute is now subject to review.
Why would that evidence still be applicable?
Why would it
still be? Remember, time is moved on.
Yes. So the time factor would affect the market value.
Yes, that's
and that's one component, but that's not the real issue in dispute here. The issue in dispute is how much gets deducted from the market value for the alleged damage.
Yes.
And that is the area of dispute, and that hasn't changed.
No, what I'm saying is the evidence presented at the 218 GV or 215 GV.
2018.
Yeah. How could that still be relevant to the 2022 GV?
So the evidence on we've got the city's structural and geotechnical engineer, Mr. Moffat, available to give fresh evidence.
That's what
yes.
it's fresh evidence.
Yes.
That's good.
Yeah. So we're not going to say, all right, you must just rely on the evidence that was there last time. But the evidence is going to be the same as the evidence that was given previously. His evidence will be that there is no structural damage. There is no evidence of structural damage.
But that's on the current situation of the GV22. You follow what I'm saying? Is you're correct in saying fresh evidence.
Fresh evidence, but the fresh evidence will be that there's been no change in the assessment of structural damage.
Okay.
And that professional view, that expert evidence on is this building structurally damaged and must be demolished, or does it just need plastering and painting? That's a matter of heated controversy. And that controversy is before the review court, and the High Court's going to have to decide on that issue, that factual dispute.
I accept that.
So there's that dispute, that pending review application. If this board now makes a fresh decision on that issue, then we've got this difficult procedural quagmire of a fresh decision which supersedes the previous decision while there's a review happening in respect to that expert evidence. It would be far more sensible to pen the current proceedings, postpone them, allow the court to decide those factual issues, and then that decision would come before the board, and the board can then decide how to deal with the new evidence in light of what the High Court would have found on those same factual issues.
No, I follow what you're saying.
So it's a matter of convenience and avoiding escalating disputes and potentially very difficult questions of procedure, because if this board makes a substantive decision, then we're likely to see a separate review application and then two review applications happening at the same time. It makes no sense for any of the parties. And then the board itself is going to be subject to another round of review.
Bearing in mind, assuming this board responds to the matter, there may still be another review.
Well, it won't be a review of the board's decision on valuation, including the expert evidence. At most, there could be a review of the decision to postpone, but it would be hard to see how that review could be brought given Ms. Phillips' attitude that the proceedings can't continue. That would be absurd. So it would be a postponement would be a clean, neat way of avoiding another round of dispute. Whereas a striking of the roll means another attempt to revive the 2022 hearing before the High Court has managed to resolve all of these allegations of bias and corruption, etc.
Why can I make an order? Matters struck from the roll can only be enrolled
after the that would be completely in order. That would be that would be a sensible way to do it.
I just want to put a stop to this in a sense. There's so many. Remember, they, in a sense, clouding it. I don't know how they framed it. They wanted to bring in an accusal application, but without bringing an application.
Yes, then there's no recusal.
If there's no recusal application, and it's just walked out of the hearing. That is quite rightly where you think you can report him to the Legal Practice Council, whoever your attorney is. That is my concern, but as I just don't want this matter to be parted and hanging in the air.
Yes. So striking from the roll with the condition that it can't be re-enrolled until the High Court review is finalised would be completely in order.
Yeah, yes. I think it's
So the only other issue would be the Parade 2 of our postponement application is that the board exercises its power to order costs of the postponement application in the wasted cost of today. Because those costs are considerable, as you correctly pointed out. The reason all these people here, we've got a geotechnical construction engineer, we've got a quantity surveyor, we've got my costs, my attorney's costs. The city is fully prepared to run a full day of valuation proceedings, and now we can't proceed. And those costs would not have been incurred had Ms. Phillips agreed to a postponement which she originally requested and which we formally proposed on Thursday last week. Then there wouldn't be these costs. Instead, they said they requested a postponement. Then when we said we agree, please let's jointly ask the board to postpone the matter. Then they said no, the matter must proceed, and all to come have this show this morning and then walk out, but now we've got the wasted costs which were entirely avoidable. So it would be appropriate for the board to award the wasted costs of today as well.
The matter of cost, I'm not going to make an immediate decision on the cost. Myself, my board will deliberate that issue of cost and will inform you of our decision in that regard. I just feel it's under the circumstances. But I'm going to start this matter from the remand removed from the roll. My order is thus that, unless there's anything else you wish to add?
No, that's all.
Okay. So the board has today, what's today's date? The 11th of April. And the board, the matter was enrolled. The case number, which is CCT 0121086 This matter was enrolled today on the board's roll for deliberation and hearing of the GV22 value of the subject property. Before we could commence the proceedings, or when we commenced proceedings, the appellant and the legal representative decided to just leave the meeting on the basis that they feel the chairperson and one of the valuers on the board is compromised. For whatever reason, they haven't given any reason and they haven't brought any recusal application on what basis they're doing so. And they just walked out. That in itself, the board takes a dim view of that. And I understand the legal representative of the city will do the necessary and report the legalism to the Legal Practice Council. Insofar as this matter is concerned, there was an application for postponement, but and the board is of the view the best way forward is to remove this matter from the roll, struck it from the roll, which to a certain extent again the appellant had an opportunity to ventilate and challenge the decision of the city in ascribing a value to a property, but she decided to walk away, which in a sense saying I'm no longer technically saying I'm no longer proceeding with this appeal. That is the board can from her behavior and conduct, which was of course unbecoming. In any event, having this transpired, the board feels the best way to deal with this matter is to strike it from the roll. But the board is going to put a condition on this striking from the roll. This matter can only be re-enrolled after the High Court review case under, I think under case number 4672/2023. If that matter is finalized, then this matter can again be re-enrolled by the appellant. Obviously, it's the appellant's duty to, or if she wishes the matter to be back on the roll, she has to apply to have it enrolled. So this matter is then struck from the roll. Thank you for what the conditions stated by the board.
Mr. Fair's decision stands.
Oh yes, and I just want to stress in terms of section 55, the municipal value stands as is at this point in time, whatever the value is. So, thank you.
Sorry, Mr. Chair, can I just add what you added previously, that you would further consider the question of cost and then hand on?
Oh yes, apologies. Yes, the question of cost was raised here. There was an application made that the board should make a cost order. The board will consider this application, but the board will not make a decision today. The board will consider, deliberate with the board, and we will consider an order in that regard, in regarding cost. Thank you. That concludes.
Let me stand over until the other don't go.
No. We'll decide what we're going to do with it. Okay? Right. Thank you. This then concludes today's hearing. All the parties are excused. Thank you for being present. Okay. What are you making?
I didn't hear anyone leaving at the end of that clip, did you? I didn't hear anyone walking away or slamming the door. In fact, I heard the beginning of another conversation that I would like to hear as they were all sitting around the table. I wonder if we'll get a copy of that recording. The City of Cape Town and the Valuation Appeal Board and the DA, MEC, Anton Bradell and his colleagues can continue to try and destroy me and my attorney We're not frightened of you. What follows is just a little snippet of a meeting, an hour-long meeting I had with the Legal Practice Council in August 2022. Our investigations are continuing. It was agreed I could make a film once I was ready to supply this to the Legal Practice Council. The fraud keeps continuing. It's a very large investigation. But anyway, here's just a little snippet of my meeting in August 2022. I'm at this meeting now with Craig at the Legal Practice Council. It's Wednesday the 10th of August, 10:04.
So let's just carry on with the procedure.
Okay.
The complaint is investigated. If there's no merit in the complaint, we think, okay, hold on, there's potential, not even clear evidence, but there's a case to be answered here. It gets referred to what is called the investigating committee. The investigating committee is made up of practicing attorneys, not employees. There's no bias. It's judgment by your peers.
There are two attorneys, Ryan Menchis, I'm terribly sorry if I pronounced that wrong, and Deirdre Oliver, with their advocates.
This is obviously a much bigger matter than...
It is going to be, and this is just the beginning, and I'm in it for the long haul. And Pashka has the audacity to ask me for costs for the 11th of April 2024 hearing. Look how much work my attorney and I had to do to prepare for this hearing. It is a no-brainer that the city should not have gone after me for a GV2022 valuation using the same reports, the same people, using ratepayers' money, your money. No, I'm not letting them get away with this.